if you call this communication, this is like saying communication between a parent and a 14-year-old child where they say, yeah, the teenager, and you know they're not listening, and they're just saying, yeah. That's what I'm getting from Mr. Gersten on serious and important issues. I was ending, you said remain.
State of Nevada versus Kim Blandino, case number 22 CR 041030. Appearances for the record. Counsel?
Mike Dickerson on behalf of the state, bar number 13476.
And Mr.
Your Honor, Joseph Gersten, 13876. I guess for Mr. Blandino. And Your Honor, I would request,
Wait a minute, my appearance, Kim Blandino appearing pro se. I'm the one that filed this motion with leave of the court.
All right.
So I filed it pro se.
So Mr. Gersten, you're going to finish?
I was just going to ask if, because it is Mr. Blandino's motion, if he could sit up here at the table, but he wants to interrupt me, that's fine.
He can stand there. He's not this is not a trial. We normally have people stand back there when we do address these matters. All right, here's what I've got.
I object to not being able to sit at the.
I understand, Mr. Blandino, here's what I've got. I've reviewed your motion. I've got a concern regarding this matter, and it's concerning to me that maybe you don't understand the procedure. My indication to you is I will allow a leave of court to file a motion to address whether or not Mr. Gersten is properly representing you, not that he should be removed as your attorney so that you can represent yourself. I've already made a determination that you cannot represent yourself under Ferretta, even though I did determine that you maybe have ability to. Based on the history of this case, of the prior cases, I've made the decision. We're here today only to determine whether or not Mr. Gersten is representing you in an adequate manner that is consistent with an attorney, and whether or not he should continue to represent you. If I make the decision that Mr. Gersten is not going to represent you, I will then appoint another attorney to represent you. State's only procedure here, only standing in this case, is if I do grant that motion to appoint new counsel, whether or not it affects the trial date. So, Mr. Dickerson, you really have no say per se in this, other than if it has an effect on the trial setting.
Which we don't even have at this point.
I've got a 222 prelim.
Just the prelim is set, right?
Okay,
And
yeah,
so,
because we won't be able to address the prelim. So if it affects the setting of the prelim because of new counsel, that's what we focus on. So, Mr. Blandino, understanding that I'm only looking towards one thing, is whether or not Mr. Gersten has fell below any requirements of representation, and whether or not he can continue to represent you. That is what we're here for today. With that being said, you may proceed on why Mr. Gersten should not be representing you, other than that you feel you should represent yourself, because I've already made the determination on that. You've already appealed that, and that process is already going on. That decision has already been made. So, what is the problem with having Mr. Gersten represent you? Are you not communicating with him? Is he not communicating with you? Is he not following through on phone calls? Is he not providing you with discovery? Mr. Blandino?
Okay, first, I got to object to what you said. It's not the adequacy of the representation per Young versus State versus said here, whether there's an irreconcilable conflict. So it's not adequacy. That would be like an ineffective assistance of counsel. And although there might be that case, I don't think it was appropriate to represent here. Secondly, I did not appeal it in the strict sense of the word. I filed for an extraordinary writ, and rather than address the merits, the Nevada Supreme Court said that they were exercising their discretion not to hear my petition for the writ.
All right.
But the thing is that, yes, there is communication problem. He doesn't answer calls promptly. Here, I've asked him repeatedly to get the transcripts that were necessary so I could even take it up to the Nevada Supreme Court with an adequate record as it was. He hasn't ordered discovery. I told him to get discovery going. There's body cam footage that was important and vital, and I know that this stuff oftentimes is conveniently lost. It was not presented at the probation revocation. I want the court to take judicial notice, which you probably already has, that there was a probation revocation hearing regarding these same facts. And I testified at that hearing, and under Cooper versus State, I believe, that testimony can be used in this case for impeachment or rebuttal only, because I took the stand.
But yeah, but that's
Yeah.
not the issue. The
No,
issue
but what I'm saying is that, they forced counsel on me on the probation revocation hearing. He didn't communicate properly, wasn't prepared for the hearing of certain facts. There's certain facts that I need for him to, know, and I don't get the calls back. I know he's a very busy guy, he's told me that over and over again. But there is a conflict because there's some very valid pre-trial dispositive motions that could be made in this case, and he just will not make them. We got a Riverside McLaughlin issue that's very important. Mr. Dickerson, as you perceptively recognized at the first hearing when I was in the mittens and high-risk transport, that Mr. Dickerson himself has a grudge. This is like a grudge, it's a personal thing. You stated that. Now, Mr. Dickerson did have umbrage at that, but I think a motion to disqualify
This isn't
would be in
about
order.
me.
He refuses
This
to
isn't
follow.
about me.
Why?
I could care less about Mr. Blandino.
Couldn't
No,
care less.
let's just, all right, listen, let's just focus on your relationship to Mr. Gersten.
Yeah, well, the relationship is that although the courts have said over and over again that counsel is not to be a mouthpiece for the defendant, either at trial or on appeal, and it's his determination to make strategic and tactical determinations as to what's best. If I can't get the communication, and for those basic things, I mean, they're basic is to a discovery motion to be filed. I've asked for transcripts of hearings, which the one time he did ask for a transcript when the court recorder or reporter, however it may be, was out due to a sickness or something, somebody dying or something, you stated that we could have the jabs, but I've asked him for the transcripts
All right, let
to
me
keep
stop you there.
current on that.
Let me stop you there, because we may not have the jabs in there. Unfortunately, one of our court reporters who had passed on, we are trying to get copies, videos, or anything. They may have been lost.
Well, what I'm saying is that the communication is just not there, it's completely broken down, and he is, we do have a conflict there. My religious beliefs are definitely important to here, it's a crucial part of this case and my practices, because I rescinded my US citizenship, the passport, the fraudulent document that is there. Mr. Dick,
Talk about the facts of the case.
no, I'm just saying, Mr. Gersten calls it a novelty passport, so he completely will not properly accept the communication that this is not a novelty thing. Although, I guess novel means new in the strict sense of the word. Most people think of novelties as something like toys, you know. It's not a toy. My ambassadorial credentials are not a toy. It's a result of my sincere beliefs and practices as a ambassador of the Kingdom of Israel, and he refuses to accept those arguments. So there may be other counsel that can properly raise those. So we got the Riverside McLaughlin, there's a motion to disqualify Dickerson that another attorney might well find meritorious. I had been given 30 days in the other case, and I was spent 45 days. So actually, there's a double jeopardy issue in that I've already been punished by spending time in jail on these cases. And as the district attorney represented previously in this court, they are agreed to dismiss the felony if I plead no contest or Alfred or guilty to the,
I don't want to know about
Those.
I want to know about the negotiations.
well, they was presented in court last time that those negotiations were there. So what I'm
I don't
saying
recall
is
it, but
is that,
I'm not concerned about the negotiations.
Yeah.
I'm looking at the communication transcripts, body cam, you and Mr. Gersten's decisions.
and Mr. Gersten, as he stated before and will state today, he does not have a problem with me. In other words, he's in agreement that I should have different appointed counsel because I may very well have someone that I can communicate with, and under the factors in Young versus State and the companion cases that I cited in that thing that are in the federal system. I mean, if I can just say, it says where a criminal defendant has with legitimate reason completely lost trust in his attorney, which I have, and the trial court refused to remove the attorney, the defendant is constructively denied counsel. I need to make it clear to this court that if you force me to go through with having Mr. Gersten as counsel, you will be denying me counsel. And it says further in Daniels, which is the Ninth Circuit case, this is true even where the breakdown is a result of the defendant's refusal to speak to counsel. Now, I have not refused to speak to him, but the problem is he refuses to speak to me adequately. Communication is part of the ethics and the rule, Nevada Supreme Court rules that there has to be adequate communication, and definitely has not been adequate. And you cannot deny substitution just because the counsel's representation is adequate. You cannot deny a substitution. So I mean, there's some very good case law, and I cited it clearly so that the court could take a look at this. The fact that, you know, this is not a frivolous motion here, and the fact that Mr. Gersten is in agreement with it. Let's see. U.S. versus Velasquez, there's no question our case law favors an inquiry where a party seeks substitute counsel. Now, I know as of to date you haven't inquired. I guess I'm basically telling you now, but I think that under Young versus State and all the other cases, based on what I present, you are obligated to do an inquiry both of me and Mr. Gersten, despite whatever representations we might find there, because all you judges have your own particularities and your personal pet peeves and then your proclivities on the other side. And I think it's appropriate here that if you find one nugget that maybe I have not touched on or Mr. Gersten has not touched on, there has to be an adequate inquiry by you to see those things that you look for to see if this is meritorious or not. And so in that respect, to cut this short, I know Mr. Dickerson has a thing. I would leave it to you to inquire now per Young versus State, which is mandatory on
I
you.
want you to make an argument, I don't want you to rush it because Mr. Dickerson, like I said, Mr. Dickerson really has no standing per se.
No, I understand that, but I think that at this point in time, you know, we've seen it over and over again when somebody goes to an appellate court, the attorney has all this stuff prepared and his time is virtually taken up with manifold questions, because oftentimes the Socratic method proves this, question and answer sometimes the best way to get to the truth and to find out what's relevant or not. So at that, I would leave it open to you doing a proper inquiry under Young versus State and the cases cited herein, which is U.S. versus Moore, Daniels versus Woodford. If you want me the complete citations, but they're in the motions, U.S. versus Velasquez, they are pretty darn thorough. And if the court could take judicial notice that the Supreme Court over and over again, even though it's not standing precedent Ninth Circuit cases, they will adopt it, because if they don't follow the Ninth Circuit case, there's a very likelihood the state court's opinion will be reversed or impugned on habeas, because they have to follow Ninth Circuit. And I will, if necessary, on this case and every other case, go on habeas or to the U.S. Supreme Court. I've already been there on this case coming out of the district court, and I've been there a few times. And so I will leave it open. I will ask that the court do its proper inquiry under Young of both myself and Mr. Gersten.
All right, anything further, Mr. Blandino?
Yeah, just would like that inquiry.
All right, Mr. Gersten, let's
Sit-
first focus on the communication problem.
Sure, Your Honor.
Well, you've heard it, so please address it and I'll see if there's any left thing.
Yes, Your Honor. With regard to communication problems, Mr. Blandino has called my office some days as many as 14 times a day. I return the calls. I can show you the billing from the Office of Appointed Counsel where I return the calls. When we are on the phone, almost every call I've had with him is almost 1 hour in length. So I don't believe there's a communication problem as he is saying. He's saying it, I'm giving you specifics. In fact, at one point, and this was heard in Judge Levitt's courtroom, he called my office claiming he had gotten stabbed and was bleeding out in the
I object,
CCDC.
Judge.
Hold on.
In CCDC. I called Post 10 and put everyone in a tizzy to find out what was going on. Turns out he was testing my messaging system to make sure I had gotten the message. So I don't believe there's a communications issue. He calls, I return the calls. I don't return 14 calls a day, Your Honor, but I do return the phone calls for up to an hour at a time. That's number one. With regard to the discovery, Your Honor, discovery was provided in this case, and the day that it was provided, we scanned it at the office and shared it via a secure 128-bit system so that he could review it online at his leisure. He's never told me before that the discovery in this case he didn't have, he wasn't able to review, nothing. The only thing he wanted was the body cam from the particular incident.
Only thing?
Can I finish?
Hold on, just let him finish.
I object the only thing.
The only thing that I'm aware of that he has requested from me with regard to discovery was the body cam. I was going to mention it in court today, so that it was on the record, Your Honor. I'm asking Mr. Dickerson to please provide the body cam from this incident. It's mentioned in the police report. If we could have that, would be most appreciated, Mr. Blandino was looking for.
Let me stop you both there. Mr. Dickerson, you have a copy of the body cam? Has there been a request?
I don't know that I have it in my file, but I can procure it.
You can, if you can get that for
Yeah.
Mr. Gersten. All right. So let's put that on as an order from the court that we produce the, you can subpoena that. This is a trial. Well, under the trial, you could.
Under the trial, this is the preliminary hearing, Your Honor.
I will give you leave, and I don't think Mr. Dickerson would object, leave to file the subpoena if you could take that.
And I don't think that they'll need to. I think I'll be able to get it over.
Okay,
to
yeah,
them.
as long as you can cooperate with that, you don't need leave. If you need leave to file a subpoena, if you just take them, I'll allow that to happen so we can get.
Again, Your Honor, I've never had an issue. If it becomes an issue, we will file a subpoena, but I'm not worried about it.
And then discovery,
Discovery's it's been provided to me. I provided it to Mr. Blandino. I'm not aware that there's anything missing from it. Mr. Blandino has not identified, again, he was at the scene. He has not identified to me that there is anything missing from the package of discovery that I have provided him. If there was, I would get it. I mean, that's what I'm supposed to do. And I'm sure Mr. Dickerson, under Brady and his progeny, would provide it as well. So I'm not worried about that, but I haven't been told there's anything missing by Mr. Blandino. With regard to the transcripts, with regard to the transcripts, Your Honor, I don't know what to say. If he wants transcripts for an appeal, there is a period of time during an appeal where he can request transcripts. I haven't been, in my professional opinion, I don't think there's been anything that we've needed to transcript up to this point that I should be requesting just yet. And we did ask for it at that one point, Your Honor, and as you mentioned, there was a death, it was jabs, there were no transcripts to have. So he wants a transcript of this. I'll ask the court reporter right now, can we get a transcript of this for Mr. Blandino?
But like I said, one of our court reporters who had passed on, and we are attempting.
And I understand, Your Honor, and I've tried to explain
Is
that
that
to,
over today's hearing as well, Judge?
I've tried to explain it to Mr. Blandino.
He moved out of state when he learned of his impending, his illness, and then rather quickly passed on. We're attempting to see if we can find any of his audio that they normally preserve. Trust me, we've worked on many cases trying to get all this. So the transcripts may be a problem that we can get. But those are pretrial transcripts, not going through the discovery of the case, right?
I don't believe so. And the only other thing that he mentioned that I take umbrage with was, it's not, I'm not sure that's 100% relevant, but I just feel like I have to speak to it, is he was talking about the revocation hearing that happened in Judge Levitt's case, that I was inadequate in that case. And I mean, I'd like to think that Mr. Dickerson would join me and say, I mean, he was found, he wasn't revoked. So I want to say that I was completely adequate in my representation. I had a good time with the officers that were called, so.
Here's the,
Judge,
Judge,
can I finish?
Mr. Blandino, please wait.
I do join it. You appeared very prepared, And what I had recognized in that hearing is he advised his client not to testify because it went against his whole theory of defense.
Well-
And then Mr. Blandino testified and admitted to everything. But he's still got
Dickerson.
he's still got to reinstate it.
I'll take the representation of Mr. Gersten.
Yeah,
Like I said, you don't have much standing, so I don't want you to get involved too much. Now, Mr. Gersten, go ahead, finish up.
So again, Your Honor, those were the 4 issues that I heard Mr. Blandino speak to just now.
How long, okay,
Were those. And so I do not think I've been inadequate or anything in those things. If Mr. Blandino again, Your Honor, if Mr. Blandino wants to represent, I mean, I know the case law is he's entitled to counsel, not counsel of his choice. Do I really want to represent him? If I don't have to, I don't want to, but as I mentioned, the Supreme Court has held me to the case,
Not this case, from the other prior case, just to clarify.
In the direct appeal from Judge Levitt's case, the Supreme Court has held me. Judge Levitt has held me to that case. I really, whatever is your pleasure, Your Honor. If I don't have to represent him, fantastic.
all right.
I'd be very happy.
How long have you represented Mr. Blandino?
Since July of 22, Your Honor.
That would be July 7th, Judge.
All right.
I was actually called by Mr. Christensen to appear at his sentencing as I was replacing Mr. Bateman, who I believe is behind me, who was initially standby counsel and then became actual trial counsel, but he's not an appellate lawyer, so Mr. Christensen had me appointed by Judge Levitt to be appellate counsel since the sentencing.
All right. So you've had represented in that, you represented in a revocation hearing?
And the revocation hearing, yes, Your Honor. Like, as I mentioned, I'm representing him in 3 different cases. The district court case, the appellate case, the Supreme Court case, and this case as well.
All right. And I understand that Mr. Blandino may be antagonistic as to his approach. Are you able to communicate with him?
I really don't have a problem here. I'm shooting myself in the foot, Your Honor.
When you say communicate with him, and I know, and I'm sorry, but.
Again, Your Honor, I'm shooting myself in the foot by being honest with you, but the honest thing is, can I do it? Absolutely. This is not an issue for me. If you let me out of the case, I'd gladly take it, but if you don't, I will ethically and functionally execute my duties as counsel.
All right. Now, you've talked to him, you're in communication with him, you've returned his phone calls?
Every time we have a phone call, it's an hour, Your Honor.
Okay. But you've returned his phone calls?
Yes, sir.
I don't
I
get my
understand that he
emails.
may have some requests for certain kind of motions or something to that effect. Have you talked to him about those motions?
I have.
Without getting too much into the attorney-client privilege,
Yes, sir.
I want to make sure that you've discussed with him those motions and your position on those motions.
We talk about the motions, I explain the motions to him, I explain my theory and my professional opinion, being an attorney for 24 years, and I explain to him exactly why or why not certain things should either be filed or not filed, etc. So,
All right.
this is not my first rodeo, Your Honor.
Okay.
Judge, if I may rebut.
Mr. Blandino, I'm going to get to you. That was my next statement.
Okay.
Just
Right.
slow down. Mr. Blandino, he's indicated that you've talked to him, he's called you back. Transcripts issues is not really his fault. There's some we can get, there's some we cannot get. But requesting transcripts of hearings that are previously, that other than for appeal issues, don't apply to the trial. The body cam, Mr. Dickerson indicated they can get that. If not, the court would facilitate a subpoena to take him either under the trial or under the preliminary hearing. Discovery has been, leads this point. Has there been any witnesses that he's asked you to review or to talk to that you have not spoken to or tried to locate?
No, Your Honor.
Okay. All right, Mr. Blandino, your response.
Well, I gotta take issue with him,
Stop taking issue, let's just get to the facts.
well, the fact is that he showed a part of the conflict here. He's speaking out of school when he talks about that call from the jail. I mean, this is confidential. I called that call. You got the authority to have, or the ability now, I should say, to make that a confidential call. Now he's exposed potential bad conduct or disreputable conduct that is taken out of context, does look bad. However, he's given it to you and given now the district attorney, ammunition that can be used against me. This was taken out of context. I'm not gonna even address that any further, but the transcript issue, Ben Bateman, my counsel, that was first standby counsel, and then once my self-representation was revoked in the case before 341767, he got transcripts every time. He was very cooperative, and he got transcripts every time after the hearing. We would put in the other thing, but then there was a couple times when I noticed that Mr. Dickerson would ask Levitt directly, Judge, can we get a transcript of today's hearing? So what I did with Mr. Gersten, and that's the only reason he asked for that at one time when the court recorder was dying or dead or whatever, I said, hey, would you ask for the hearing? He says, well, there's a process for doing that. We don't need the process because Mr. Dickerson had already set the precedent that if he asks for a transcript, the judge just gives it to him. As for the body cam footage, oh yeah, now it is, but the thing is, there have already been negotiations done. I have made, the Dickerson made an offer, and I had Gersten make a counteroffer. I don't know if he presented it to Mr. Dickerson.
Let's not get too much.
What I'm saying is that body cam footage is definitely important to any negotiations. That I don't know if Mr. Dickerson has reviewed it or not, but to have it at this late date, when it's been available all this time, it's been available all the way to probation revocation. Now, why he says he did represent me adequately, I begged him to get the transcript of the probation revocation hearing that day, and he did not do it. So communication, if you call this communication, this is like saying that communication between a parent and a 14-year-old child where they say, yeah, the teenager, and you know they're not listening, and they're just saying, yeah. That's what I'm getting from Mr. Gersten on serious and important issues. And so I've sent emails, I have gotten emails in response. I sent emails about the transcripts, he said, send me the dates and times. Then I send him the dates and times, and then when he comes over here, oh yeah, I got that on my notes. Well, that was a month and a half ago that I sent you the dates and times. So I may be wrong on the exact timing, but it was plenty of time for him to at least put in the request for the transcripts. Now, those transcripts are vital. They go to the probation revocation hearing. So even though there's some bleed over, which there must be because he represents me in the hearing, the post-sentencing issues before Levitt and on the direct appeal, that transcript is vital. That goes to, just like a bail issue isn't just what's on in this case, it's where you had any prior failure to appears and that kind of thing. So we have a history between he and I, and this history is that he's very busy. He tells me he's busy all the time. He gives me this line, you're not my only client, Mr. Blandino. If I have to judge the performance, and I can, between Mr. Gersten and Mr. Bateman, although I had issues with Mr. Bateman being forced upon me, it's like a night and day. Mr. Bateman was
Let me
very,
stop you there
very...
for a second. Mr. Bateman, I see that you're in the courtroom, and I'm wondering why. And I'm asking this for this one reason, because the next question you may not like. Mr. Blandino, I've indicated that you're not going to be representing yourself. Mr. Gersten is court-appointed counsel. If I replace Mr. Gersten, I do not expect any more problems. You indicate that Mr. Bateman would be sufficient to handle this matter. If I appoint Mr. Bateman to represent you, would that satisfy you, where you don't have to then, because if you keep coming back that you want this and this, and Mr. Bateman now says, I'm not gonna file this motion, because I think it's a frivolous motion, I do not believe in the merits, or it's not, we have certain requirements, Rule 11 requires those only to file motions that we believe are either bound in case, or we believe have a legitimate argument for overturning current case law. So we're, as attorneys, restricted in what we can or cannot do. So you've indicated that although, and Mr. Gersten, I've always respected you and think you're a wonderful attorney. I think you've done a great job. And maybe I can relieve you and thank you for that.
Gladly.
But if Mr. Bateman, who is unfortunately sitting back there, I have no problem appointing, but Mr. Bateman, if you do not accept the appointment because you don't want to, because this is an off-track appointment.
Yes. If I just may make some representations, and Judge, I'm here mainly, yes, out of just morbid curiosity.
Don't say morbid,
Curiosity
Mr. Blandino,
as to the outcome.
I was asking.
And I will state, Judge, that for most of my time, I was standby counsel for Mr. Blandino. He was the attorney, and so I would request the transcripts. However, when those roles switched, I did not. And if you want to ask Mr. Blandino, that I did not get transcripts when I was the attorney because I didn't think they were necessary.
all right, let me
So
ask
those
you.
things, it's different, obviously,
That's
the
not my
skill set.
recollection, Judge.
In
Mr.
addition,
Blandino.
I don't think it's wise because he's appealing that, I did represent him at trial, and he's appealing that
Okay.
trial, so it wouldn't
So
be
it's,
proper
the
to
issue
accept
of
the
ineffective
appointment.
assistance of counsel is somewhat on the back burner, or if not, at least appealed.
I would assume so, yes.
As for you,
You can't raise ineffective assistance of counsel issues on direct appeal, so therefore it's
Mr.
not
Blandino.
part of that.
um,
Wouldn't be.
with the understanding is, you know, I've handled many murder cases. I think ineffective comes with the territory.
Correct.
So, I mean, I'm not questioning your abilities. We all get questioned on ineffective regardless. That is a trial tactic that the appellate courts do. I'm not
Understood. So
questioning- So I'm not trying to question your ability.
You're
So you would not be willing to represent?
I would not, Judge.
All right, thank you very much. Mr. Blandino, have you spoken to any other attorneys that you wish to hire? You're not able to hire your own attorney, correct, Mr. Blandino?
Yes, I do not have the funds to do that.
All right, is there anybody else that you've spoken to that you wish to have take over this case?
Well, what's interesting is,
That's not my question. My question is very simple. Have you
yeah,
spoken to-
Stephen Altig, his name is right there. He was appointed for me prior to Ben Bateman, but he had to conflict out because Federico, who was a complaining witness and judge, he had appeared before, so we don't have that problem there. Mr. Altig, I had a pretty good relationship with, and I think he's a very competent attorney. He raised some very nice issues in talking with him. He was going to be an expert witness, was prepared to testify upon subpoena, but then would not, and did not subpoena him. And so, Altig would be very fine. I understand he's on the track. It looks like he's on the track even for this court itself, because I see his name
I'm
on
not gonna
there
put
on
him on
that.
track, though. If I'm appointing off track on this, if I'm gonna punish him like that. I'm definitely not gonna, he needs to be paid for this, because it's not, I'm not gonna put track on this. What he's gonna have to.
Well, Judge, for clarification, what do you mean off track?
Whether or not he gets paid, he's paid to represent people in this department for conflicts that public defenders have. If I go off track, that means that he's gonna be paid.
Well, the public defender has conflicted out. They will not represent me.
I hesitate to even think, because I like Mr. Altig, I think he's a wonderful attorney. My concern is that no matter who I appoint, I don't care if it's a person of Clarence Darrow's stature, that it wouldn't matter. Mr. Blandino is hell-bent on representing himself in this matter, which that's not gonna happen.
Again, Your Honor, that,
District court.
again, I'm shooting myself in the foot here, but literally, that's what the Supreme Court has said, that's what Judge Levitt has said, so
What is that?
just so that you're aware.
All right. All right, here's what I've got. I understand there's a disagreement between Mr. Blandino. I'm looking at the history of his cases that he has. I'm concerned that maybe he just doesn't agree with Mr. Gersten. I'm afraid if I appoint somebody else, he may not agree. If you want to talk to Mr. Altig and see about Mr. Altig coming in and allowing the substitution to come in, I will agree to appoint Mr. Altig off track so that I can then have him paid for his representation. And if Mr. Altig wants to come in on that and substitute in, I will appoint off track. Other than that, I think that this disagreement is because Mr. Blandino's desire to represent himself, which the court has ruled that he may not, following the rules and regulations or the orders by district courts and Supreme Courts. Further, Mr. Gersten has been ordered to stay on these cases, has represented Mr. Blandino, is a very competent attorney. The disagreement they're having is regarding trial tactics, which you're going to disagree with many times with clients. There's many things they want you to file, many things they want you to ask or argue that may not be proper or may hurt their case, and you rely upon the adequacy of your attorney in making that determination. Based on the hearing today, I do not find Mr. Gersten should be replaced. With that being said, Altig is being offered as an alternative. If Mr. Altig wants to come in on this matter, I will agree. You'll file a motion to substitute it in let him know that I will go off track on him and point him on that matter. That's the order of this court at this time. We have a prelim date scheduled for the 22nd, is it, of February?
I believe so.
We're keeping that date?
Yeah, we can keep that.
All right, that date will remain.
Judge, for clarification, then I don't have to go and hunt down Mr. Altick and talk to him, that's being up to Mr. Gersten to do?
If you want to speak to Mr. Altick and see if Mr. Altick wants to represent you, he's limited on what he can speak to you about because you're represented by counsel, but seeking new counsel is one thing. But that's a limitation that you probably wouldn't talk to Mr. Altick. If Mr. Altick then says he wants to be substituted in, and Mr. Gersten, I don't think you'd object to that.
All right.
With the, and I trust Mr. Altick that if he approaches him, he can only speak to him about certain things because he is limited once a person is represented. All right? See you back here on the next return court date. That date again will be?
February 22nd at 9:30.
Thank you, Your Honor.
Thanks, Judge.